Well, good afternoon, everybody. Apologies for the very slight delay, but thank you for joining us all for the second in our Actions Against the Police series. In the webinar just before Christmas, you had Russell talking you through negligence, assault and battery and harassment. Today we're focusing on, as you can see on your slide there, human rights and the police. And then Kerry is going to be talking to you about misfeasance and malicious prosecution. We will endeavour to deal with any questions that you have as we go along. If you put them in the chat box at the bottom, please don't put them in the Q&A or we lose them, and we will see if we can deal with them as we go along. But without further ado, I'll get stuck into the Human Rights Act. So just to give you a quick overview, I'm going to go through the structure of the convention very, very quickly, the Human Rights Act, how it works, look at some of the rights that are often engaged in cases against the police, and then have a look at a few cases that have dealt with some of the positive duties that are imposed upon the police by the Human Rights Act. So, as many of you, well, all of you I'm sure know, the European Convention on Human Rights is an international treaty. All 47 members of the Council of Europe, which automatically includes any and all members of the EU, are signatories. It entered into force in the early 1950s, and very much in the shadow of the Second World War was intended to prevent the atrocities of that conflict from reoccurring. But it is a living instrument, and its modern application is much wider, and it's been applied to a much wider range of circumstances. Next slide, please. It's enforced by the European Court of Human Rights, which I'm going to call the ECHR for the remainder of this talk, because that's a bit of a mouthful. And the ECHR has the power to make judicial decisions binding on contracting states. It can be accessed by an individual only after they have exhausted all domestic remedies before petitioning the court. So it's a court of last resort, and not a very practical remedy for individuals. So this is where the Human Rights Act comes in. Next slide, please. It incorporates the convention rights into English law and allows individuals for the first time to directly enforce those rights in English courts. It's therefore often described as bringing the human rights home. Section 2 requires the court to take into account ECHR case law. The domestic courts don't have to apply such decisions, but in practice they are unlikely to depart from them. And where the ECHR has not ruled directly on an issue, the domestic courts will follow binding domestic court case law. Section 3 requires the court to interpret legislation in a way which is compatible with convention rights, so far as it is possible to do so. But that is quite far, because the courts may even imply words into legislation. However, if it's not possible to interpret primary legislation in a way which is compatible with the convention, then the domestic courts must follow that legislation. So parliamentary sovereignty is thus preserved. Section 4 allows the court to declare domestic legislation incompatible with the convention. That power is restricted to the High Court and above. And note that the courts don't have the power akin to, for example, the US Supreme Court's power to strike down any legislation which they declare incompatible with the convention. That legislation will remain good law unless and until Parliament chooses to address it. So again, parliamentary sovereignty is preserved. Next slide, please. And then we get into the nitty-gritty of how it's practically used. So Section 6 makes it unlawful for public authorities to act or fail to act in a way which is incompatible with convention rights. And sections 7 to 9 deal with the rights of victims. I should say, although it's obvious, section in relation to Section 6, the police are a public authority. And Section 7.1 restricts the right to bring proceedings against an authority or in proceedings to rely upon convention rights to victims or would-be victims. And I say would-be victims because although the court won't decide a hypothetical case, a person may be a victim where there is an anticipated and real risk of a breach. So for example, an example of that, you see the case of Suring in the United Kingdom, an extradition case where there was a concern about a person suffering Article 3 treatment if they were subject to extradition. And a victim includes anyone directly or potentially affected by the act, as well as their relatives and dependents. Next slide, please. It's important to note that Human Rights Act claims have their own limitation period. That is a period of 1 year from the date on which the act complained of took place, or such longer period as the court or tribunal considers equitable, having regard to all the circumstances. And it's been held in the Supreme Court case of Rabone that it may be appropriate to take into account the factors listed at Section 33 of the Limitation Act 1980. But the words of Section 75B of the Human Rights Act mean what they say, and the court should not attempt to rewrite them. There can be no question of interpreting Section 75B as if it contained the language of Section 33(3). So it's been held that it's a discretion that's unfettered. When the tribunal considers what is equitable, having regard to all the circumstances, they should not fetter themselves by constraining themselves to Section 33(3) considerations. And the courts have consistently recognised that the short limitation period allowed in human rights cases underlines a policy that they should be dealt with swiftly and at proportionate cost. By definition, as we've seen, they're brought against public authorities, and as we're going to see in the next slide, they are usually of modest value. Next slide, please. So looking then at questions of remedy, under Section 8, the court might grant such relief or remedy or make such order within its powers as it considers just and equitable. No award of damages shall be made unless the court is satisfied that an award is necessary to afford just satisfaction. And there may be cases where simply a declaration that the right has been violated will afford just satisfaction, and there's no need for a separate award of damages. In assessing the value of any award of damages, courts should be guided by the clear and consistent practice of the UCHR, and the most reliable guidance will be awards made in comparable cases brought by applicants from the UK or other countries with a similar cost of living. The reason for that being, of course, that the value of money will be different depending on the cost of living in different countries. And the awards, as I said before, are generally modest. In that case, it's cited on your slide there, Faulkner, Lord Reed further cited Lord Bingham in a case called Greenfield, where Lord Bingham held that the Human Rights Act is not a tort statute. It's relevant that even in a case where a finding is a violation is not judged to afford the applicant just satisfaction, that finding will be an important part of the remedy and an important vindication of the right that's been asserted. Next slide, please. So that's the basic structure of how the Human Rights Act works. I'm going to look now at some of the rights which are likely to be engaged in claims against the police. The first being Article 2, the right to life. And there is, of course, a negative duty to refrain from taking life, although there are exceptions to that negative duty, where the deprivation of life results from the use of force which is no more than absolutely necessary in defence of any person from unlawful violence, in order to effect a lawful arrest or to prevent the escape of a person lawfully detained, or in action lawfully taken with the purpose of quelling a riot or insurrection, all of which, as you can well imagine, could be involved in claims against the police. Next slide, please. But the right under Article 2 goes further than that negative right. Article 2 imposes positive duties to protect life by law. The operational duty that includes a duty to put into place effective criminal law backed up by law enforcement machinery and a duty to take preventative operational measures to protect an individual whose life is at risk from the criminal acts of another. Next slide, please. Article 3 is the freedom from torture. It is an absolute right, so any violation is not capable of justification and there's no qualification. Again, positive duties are imposed to do what is reasonable in all the circumstances to protect people from a real and immediate risk of harm. But the police have been afforded a measure of latitude. I've given the example there of the House of Lords case of re a child. That's a case where the police were held not to have breached their obligation under Article 3 in relation to steps they had taken to protect parents and children from violence when walking to and from school in Northern Ireland. Applying the doctrine of proportionality, Lord Carswell held that the police were uniquely placed through their experience and intelligence to make a judgment on the wisest course to take in all the circumstances. They had long and hard experience of the problems encountered in dealing with riotous situations in urban areas in Northern Ireland. The difficulty of catching and arresting malefactors who had means of retreat available through paths and gardens are self-evident. The police had available to them sources of information about what was happening in the community and what was likely to happen if they took certain courses of action, which they were experienced in assessing. He held that the evidence supported the overall wisdom of the course adopted by the police. So that experience of the police will be respected by the courts, and they will be afforded a measure of latitude. Next slide, please. The court has never sought to issue rigid guidelines for the type of behaviour that Article 3 prohibits, and that's in order that it might continue to reflect the changing standards of the modern world. As I said, the Convention is a living instrument, and it reflects changing standards. But in 1978, in the case of Ireland and the United Kingdom, the ECHR did give some definitions for torture, inhuman treatment, and degrading treatment. So torture is treatment constituting deliberate, inhuman treatment, causing very serious and cruel suffering. Inhuman treatment is treatment causing, if not bodily injury, at least intense physical and mental or psychiatric suffering. And degrading treatment is that which would arouse in victims feelings of fear, anguish, and inferiority, capable of humiliation or taking away one's physical or moral resistance. Article 3 is also subject to a basic de minimis requirement, so treatment must reach a minimum level of severity. Again, the courts have been reluctant to issue any exact guidance as to what that minimum level is, and it will be decided on the facts of each case. But a relevant circumstance to which the courts will have regard is the age of the victim. Next slide, please. Article 5 is the deprivation of liberty. Of course, police routinely deprive people of their liberty in cases of arrest, and that, of course, doesn't violate their Article 5 rights. But the general principles implied by the Convention to which the Article 5.1 case law refers are the principle of the rule of law and of legal certainty, the principle of proportionality, and the principle of protection against arbitrariness, which is moreover the very aim of Article 5. All of those, of course, in domestic law are enforced to some extent by our law in relation to wrongful arrest, the Pace Code of Conduct, and so on. Guidance from the ECHR itself notes that the use of stop and search powers can entail a deprivation of liberty, notwithstanding the short duration of the measure, and that a person may be deprived of their liberty even if not handcuffed, put in a cell, or otherwise physically restrained. And one other interesting factor of Article 5 is that by Article 5.5, everyone who has been the victim of arrest or detention in contravention of the provisions of that article shall have an enforceable right to compensation. Next slide, please. And the last right that I'm going to look at today is Article 8. This is the right to respect for private and family life, home and correspondence. It is a qualified right, and therefore there shall be no interference by a public authority with the exercise of this right, except such as is in accordance with the law and is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, of relevance to the police, for the prevention of disorder or crime, or for the protection of health or morals, or for the protection of the rights and freedoms of others. And as we'll see when we come to look at some cases a little bit later, Article 8 again imposes both positive and negative duties. Next slide, please. So how does all of this interact with our common law of negligence? Those of you who saw part 1 or some of the other webinars we did last year, or indeed anybody who's practicing this area of law for any period of time, will know that the police will not generally owe a duty in respect of omissions to act or failures to confer a benefit. As I say, for more detail on that, see our previous webinars, see the line of case law that starts with Hill, and has been clarified later in cases, Supreme Court cases like Michael and Robinson. And watch this space as Tyndall is due to be heard in the Supreme Court in 2 weeks' time. So there may well be more on the common law duties in relation to omissions that are imposed on the police. But for today's purposes, I'm not going to talk any more about negligence, save that to say that generally speaking, the police are not under a positive duty to take action under the law of negligence. But as we've seen, the Convention rights do frequently impose positive duties to act, and therefore, as a result of the Human Rights Act, claims can be brought for failures to act against the police. It's important to keep in mind, and we'll see as we go through the cases, that people haven't always, but that whilst sometimes claims might arise out of the same facts, both at common law and under the Human Rights Act, they are distinct causes of action. A submission that the common law should develop in line with the Convention was rejected by Lord Nicholson in the case of Michael, the Chief Constable of South Wales Police. In that case, It was argued on behalf of the claimant that effectively the law of negligence should recognise the same duties as are imposed under the Human Rights Act under Articles 2 and 3. And Lord Nicholson held, if we have the next slide, please, that on orthodox common law principles, I cannot see a legal basis for fashioning a duty of care limited in scope to that of Articles 2 and 3, or for gold-plating the claimant's convention rights by providing compensation on a different basis from the claim under the Human Rights Act 1988. Nor do I see a principal legal basis for introducing a wider duty in negligence than would arise either under orthodox common law principles or under the Convention. And where he talks there about gold-plating the claimant's convention rights, as we've seen, there are disadvantages to a claimant in a Human Rights Act claim. They have a shorter limitation period, the compensation is generally less generous. So you can see why claimants might want to be able to extend those convention duties into the law of negligence, but courts have been resistant to that. Next slide, please. So let's look at how these positive duties from the Convention work in practice when they're imposed upon the police. The first and sort of most famous case that we're going to look at is that of Osman in the United Kingdom. It's a case that predates the coming into force of the Human Rights Act, or it's the Human Rights Act 1988. It didn't come into force until 2000, and it was a claim brought in negligence. It was brought by a young boy and his mother in respect of the shooting of the young boy and his father by a teacher who had become disturbingly obsessed with that boy and had carried out a pattern of harassment of the family over a number of months. He had carried out acts of criminal damage against his family home, and it was their case that the police had failed to protect the lives of the second applicant and his father, and had failed to prevent the harassment of the family. They brought that claim in negligence because, as I say, this predates the coming into force of the Human Rights Act, and it was struck out by the Court of Appeal based upon what was then understood to be the Hill immunity from suit. And that striking out was held by the ECHR to be a violation of Article 6.1. They held that although the exclusionary rule in Hill may be accepted as a legitimate limitation on the right under Article 6.1, its application in any case must be proportionate. And that they held that the Court of Appeal had proceeded on the basis that Hill provided, quote, a watertight defence to the police, and that it was impossible to prise open an immunity which the police enjoy from civil suit in respect of their acts and omissions and the investigation of suppression of crime. And such a blanket immunity was held to amount to an unjustifiable restriction on the applicant's Article 6.1 rights. They did later accept in a later case that was probably based on a misunderstanding of English law, but that was the finding in that case. But as to the substantive complaint that was made by the applicants about a violation of their rights under Article 2, on the facts, the ECHR held that there was no infringement of their rights under Article 2, that effectively that there hadn't been a real and immediate risk of which the police should have been aware that would have given rise to a positive obligation under Article 2 to act. Nevertheless, such an obligation does exist, and the court in Osman were keen to stress that not every risk to life requires the police to take operational measures to prevent the risk from materialising. So the positive obligation under Article 2 must be interpreted in a way which does not impose an impossible or disproportionate burden on the authorities. And they noted that the police must exercise their powers in a manner which respects due process and the guarantees contained in Articles 5 and 8 of the Convention. So, of course, sometimes it might be necessary to balance the rights of the applicants against the rights of suspects and their rights under Articles 5 and 8. Next slide, please. But the duty that was held to be owed was that it must be established to the court's satisfaction that the authorities knew or ought to have known at the time of the existence of a real and immediate risk to the life of an identified individual or individuals from the criminal acts of a third party, and that they failed to take measures within the scope of their powers which, judged reasonably, might have been expected to avoid that risk. So you can see there's certain limitations on the extent of the duty there. There must be a real and immediate risk. It must be to an identified individual or individuals, not simply to the public at large. And the police will be judged reasonably based on what they might have been expected to do in the circumstances. Next slide, please. Sorry, but before I go on to DSD, the other thing I should say is that threshold has been held to be quite a high one. It's not been met. There's been no violation in the facts of cases like Van Cole, the shooting of a prosecution witness by a defendant, or the case of Mitchell involving the murder of a tenant after a meeting with the local authority. Where there have been violations, they've tended to include detained patients or voluntary psychiatric patients. And in 2019, there was a groundbreaking decision of the Supreme Court in DSD and Commissioner of the Police of the Metropolis. This was a case which arose out of allegations that the police had failed to carry out an effective investigation into the black cab rapist John Warboys. The claims were brought by two women who were victims of sexual assault, and their claims at first instance in arguing that the police failures in investigation violated their Article 3 rights were successful. The Supreme Court's judgment I find quite a difficult one to read. While there was agreement as to the result, and the court were unanimous as to the result, which was the dismissal of the defendant's appeal, the 5 judges in that case gave 4 speeches, with Lord Hughes dissenting on many of the key issues. And Lord Mance noted again in his speech a difficulty that's been raised numerous times by the courts in identifying a consistent line of authority in the ECHR case law. But some key takeaways from the case are as follows. The Convention imposes a duty that complaints of ill treatment amounting to a violation of Article 3 be properly investigated. That duty is not solely confined to cases of ill treatment by state agents, as had been thought. It extends to cases of ill treatment by private individuals. And the court clarified that operational failures might constitute infringement of the Article 2 and Article 3 duty, not just systemic failures. Lord Hughes had argued that it should extend only to systemic failures, but Lord Neuberger pointed out the difficulty in distinguishing between those in practice. So, for example, an operational failure by an individual police officer might be clearly classed as an operational failure, but if it's based upon his poor training, well, there's a systemic failure in relation to training him. So trying to distinguish practically in any case what's an operational and what's a systemic failure is very challenging. Another argument was made for harmonisation. At this time, the defendant argued that there should be an exemption from liability for the police in Human Rights Act claims similar to that at common law. And again, that argument was rejected. So it's a reverse, really, of the argument that was made in Michael. But again, the court is noting there are 2 different causes of action here, and they held that those 2 different causes of action have different purposes. The common law claim entails a consideration of what is fair, just, and reasonable, whereas under the Convention, there either is a duty or there isn't. And compensation was awarded in that case, irrespective of the fact that the claimants had already received damages both from the rapist and from the seeker. That the awarding of compensation was held to be geared principally to upholding standards concerning discharge of the state's duty, and therefore, where civil claims might be held to compensate for loss, Human Rights Act claims are intended to vindicate convention rights, and there is a distinction there. Next slide, please. The defendants in that case, as in so many, advanced a floodgates argument, and therefore Lord Neuberger was keen to stress that while a duty was owed in respect of purely operational failures, not every failure would be an infringement of the duty. And therefore he held it is because of the concern expressed in Osman at paragraph 116, that was cited on a previous slide, that it is important to emphasise that only serious defects in any investigation can lead to the conclusion that there has been an infringement of Article 2 or Article 3. Accordingly, I conclude that a claim based on serious defects in the performance of the investigatory duty under Article 3 and equally under Article 2 can succeed even if defects are of a purely operational as opposed to a systemic nature. But Lord Hughes was not convinced by this distinction between serious defects and more trivial defects. He thought that the distinction between systemic and operational defects that he'd contended for was no more difficult than this proposed distinction between errors which amount to breaches of Article 3 and those that do not. He said, and I quote, "To say that the errors must be serious and significant in order to amount to a breach of Article 3 is surely more to present than to solve the difficulty." But despite the fact that, as I say, it's a somewhat challenging decision to read, it is now abundantly clear that serious operational failures in the investigation into crimes involving serious violence, whether carried out by state agents or not, will violate Article 3, and that a victim of such crime will be entitled to compensation where there have been failures to carry out a sufficient investigation. Next slide, please. And an example of a claim recently brought on that basis is the case of CJ and the Chief Constable of Wiltshire. That was a case about children who were all victims of sexual abuse. The police had received a report that the abuser had images of indecent images of children on a laptop that he used, and they failed to adequately investigate that report, thus giving him the opportunity to continue to be around children. He made a disclosure and borrow service application. He was allowed to be around his niece and nephews, and therefore went on to abuse those children because he hadn't been stopped when the report of the indecent images on his laptop was made. There's an interesting discussion of limitation in that case, in which I think it was Mr. Justice Martin Spencer considered issues surrounding the date of knowledge, which he held would always have been outside of the 1 year period, and held that the court would be slow to find that claims involving serious sexual abuse would be time barred, and further considered the relevance of the fact that children being minors, the limitation under the Limitation Act, because there was a concurrent negligence claim, would not start running. And in those circumstances, he considered it equitable to extend the Human Rights Act limitation period, even though that doesn't contain the same concern about children being minors. As I say, the claimants brought claims in negligence and under the Human Rights Act, and both were dismissed. Although, as I say, as you see at the top of that slide, permission has been given by the Court of Appeal, and I believe that's due to be heard later this year. But the court held that the duty to conduct an Article 3 compliant investigation only arose when an allegation of treatment contrary to Article 3 had been made. Although the claimants did go on to suffer sexual abuse which did amount to inhuman treatment, the initial report to the police related to the downloading of indecent images, and that did not amount to such treatment. The police were only under a duty once the reports of abuse were later made, and that duty could not be, as the claimants argued it should be, extended retrospectively to the initial report. Next slide, please. And then the last claim I'm going to look at quickly, as I'm overrunning my time before I hand over to Kerry, is the case of Bell and the Commissioner of the Police of the Metropolis. This was a case about a child abduction. A mother arrived at a police station with her child, packed suitcases, and made a complaint of domestic violence against the father. She made quite clear her intention to take the child back to her home country of Brazil, and while she was there, the father made a 999 call, reflecting rather his concern that she was going to try to take the child out of the country. The police arrested him in respect of the domestic violence allegation that was made, and he then again requested that the child's passport be withheld. That was relayed to the police station, and the mother was voluntarily, and that was important, surrendered it to the police. The father was taken into custody, the mother went home, and the next day she came back, requested back the passport that hadn't been taken, but had simply been voluntarily surrendered, was given it, and she left the country with the child. The police failed to tell the father about that, and he was taken that morning to the magistrate's court and was completely unaware that the passport had been returned. And was unaware for some time that the child had already left the country. He brought a claim in negligence and under the Human Rights Act, and in the latter claim sought reimbursement of his legal fees and expenses associated with trying to secure the child's return. He had spent a lot of money, various trips to Brazil, and had tried hard to get the child's return. There was a positive duty to take necessary steps to ensure protection of the father's Article 8 rights on the police. And the court rejected an argument that was made that primary interference with family life was by the mother, who of course was the person who had actually taken the child out of the jurisdiction, and not by the police officers. The court held that the police officers, by their actions, have given, again, presented the opportunity for that act, and therefore Article 8 was engaged in their actions. There was a real and imminent risk that the mother would abduct. She said she was going to, and so the officers knew or ought to have known that the claimant's family life was at risk and that therefore his Article 8 rights were engaged. There were multiple failures in this case to comply with the police's own standard for operating procedure, failure to document decisions, including the decision to return the passport, a failure to carry out risk assessments to tell the claimant that the police had been returned, significantly a failure to put out a port alert, and a failure to signpost the claimant to legal advice. So unsurprisingly, in all those circumstances, the Article 8 rights were found to have been violated. And importantly, the officer's actions did not strike a fair balance between the competing interests of the child, mother, father, and the wider interests of the state. Significantly, the judge held no evidence of consideration of the child's best interests, which of course should have been paramount. Causation was made out. An argument was made again that the losses were caused by the mother and not the police, and that was rejected on the basis that police actions directly allowed the mother to abduct the child and thus directly caused the losses. And a declaration alone was not just satisfaction in that case. £28,000 was awarded for anxiety and distress, and in particular it was noted that there was no evidence of an apology having been made which had contributed to that distress. And damages were awarded in full for the pecuniary losses of the legal fees, including future losses or future claims that were going to have to be made. Once again, an argument was made for harmonisation between the law of negligence and the Human Rights Act. The defendant argued that if those losses wouldn't be recoverable in the negligence claim as pure economic loss, then they should not be recoverable in the Human Rights Act claim. In fact, the negligence claim also succeeded, and the judge held that the losses were recoverable in the claim in negligence. But she still held that in any event, even if they had failed in the negligence claim, she would have allowed them in the separate Human Rights Act claim. And she noted that an approach to awarding damages should be no less liberal than those applied at Strasbourg. Otherwise, one of the purposes of the Human Rights Act would have been defeated, in that the claimant would still have had to go to Strasbourg for just satisfaction. And as we've seen, the purpose of the Human Rights Act is to bring human rights home. So that was a very quick tour through some recent positive duties that have been imposed upon the police and Human Rights Act claims. And I'm going to hand over now to Kerry.
Thanks very much, Ella. So I'm going to take us all through the torts of misfeasance in public office and malicious prosecution. As a warning now, these are two torts that are conceptually and evidentially very, very complex. And what's going to be provided is an overview of the types of issues to look out for when presented with these types of claims. They are very, very specific because they do relate to an abuse of public power. And in this case, I'm going to be looking at an abuse of powers held by the police. It's by no means comprehensive, and as we'll see, there are some very specific and sometimes counterintuitive issues if we're used to dealing with torts like negligence. So starting off with misfeasance in public office, this tort is generally invoked when a public officer has exercised or failed to exercise their power as a public officer in bad faith, knowing that the act would probably cause harm. And the overall rationale behind this is that executive and administrative power shouldn't be exercised for improper purposes, and in particular to the detriment of those for which it's meant to be of benefit. So the leading case is Three Rivers District Council and the Governor of the Bank of England, number 3, where Lord Stayne set out that the tort of misfeasance in public office is an exception to the general rule that if conduct is presumptively unlawful, a good motive will not exonerate the defendant, and that if conduct is lawful apart from the motive, a bad motive will not make him liable. And the rationale for the tort is that in a legal system based on the rule of law, executive or administrative power may be exercised only for the public good and not for ulterior or improper purposes. Generally, people refer to the two limbs of targeted and untargeted malice, which is maybe not always the most helpful way to look at it, because there is some case law that says targeted malice is just the most extreme version of the tort. But looking at those two limbs, so targeted malice is where the public officer performed or omitted to perform an act with the purpose of injuring the claimant. And untargeted malice is where that conduct was known to be unlawful and they knew that it would injure the claimant. So both limbs require an invalid, unauthorised or unlawful act. And where the claimant is relying on the second limb, so untargeted malice, where the intention requirements are lower, they need to also establish that the public officer exceeded their powers. And the conduct, where the conduct complained of is by a police officer, either of them can come into play. So targeted malice, it occurs very rarely. It's hard to establish evidentially because the claimant needs to prove that the public officer in question intended to cause them harm. So, for example, it would be made out if a police officer sexually abused someone, but beyond that, it's unlikely to be discharged in the vast majority of the circumstances. So we're much more likely to be looking at untargeted malice, and all of these requirements here need to be made out to a public officer. But if it's an action against the police and it's conduct by a police officer, that's going to be made out. If it's an act or a failure involved in the exercise of power as a public officer, and we'll come on to the rest of these in a second, it needs to be done in bad faith, and it needs to have caused actual harm or injury, and that harm or injury must have been foreseen as probable. So the conduct complained of is an exercise of that power as a public officer. So not everything done by a public officer in the execution of their role will amount to an exercise for the purposes of misfeasance. So, for example, in the case of Calvi and the Chief Constable of Merseyside, a police officer made a false report to their superior officer, which was defamatory of a suspect. The report was made maliciously, and therefore the defence of qualified privilege wouldn't have applied in defamation. But however, the claim lay in the tort of defamation and not in misfeasance, as the making of the report wasn't an exercise of their power as a public officer. So it's not everything that they do in their role as a public officer that will necessarily fall within the tort of misfeasance, even if the rest of it is made out. And so that's something that we need to keep an eye on if a claim does come in. The tort can also be committed through a failure to act, so it can be committed through an omission, but that is only where there is effectively a legal duty to act, and the failure to act is an unlawful breach of that duty. And to succeed on the basis of an omission, the claimant will need to show that the officer was aware of that duty, but consciously or willfully chose not to act. So bad faith, unsurprisingly, is a key component. So either for the first limb, for targeted malice, the conduct was specifically intended to harm or injure. So conceptually, that's quite easy, although, as I say, evidentially it's going to be much more difficult in real life. But the second limb, so for untargeted malice, the claimant has to prove that the public officer either knew that they did not have the power to do the relevant act, or were subjectively reckless as to whether or not they had that power. And they must also prove that the officer was at least subjectively reckless as to whether or not harm would come about as a result. And unless they're able to establish both of those limbs, they won't establish bad faith for untargeted malice. So it needs to probably cause harm. So the defendant must know or be subjectively reckless as to whether or not their conduct will probably cause harm to the victim. Now, following Three Rivers, this was originally thought to either so the identity of a specific person or to a limited class of individuals, but that's not the case. So in the case of Akenzua, I'm probably butchering that, but my apologies, Akenzua versus the Secretary of State for the Home Department, that was a case which involved a police informant who was liable to be deported, but deportation was delayed by the deportation officer. They had known that the informant was dangerous and that if they were left at large, they were likely to kill someone, albeit that the deceased herself was not known as a potential target. The officer nonetheless delayed deporting them, presumably because of their usefulness to the police. And the Court of Appeal held, provided that the other elements of the tort were in place, it would be complete if the public officer knew that somebody may be harmed in the way that they were. And as the quote said out there, what matters is not the predictability of the informant killing the deceased, but the predictability of his killing someone. It will be a sufficient pleading in a case where the consequence of misfeasance in public office is alleged to have been personal injury or death, that the harm in contemplation was either a known victim or victims, or one or more victims who would be unknown unless and until the expected harm eventuated. So clearly it's the type of harm, but there's no requirement of proximity. And again, as we've already touched on, reckless indifference to harm is sufficient. So if they're aware that they'll probably cause harm, they don't need to know that it actually will be caused. And in relation to that, there's the case of TSB and the Metropolitan Police Commissioner, where it was held that it was sufficient to establish some degree of awareness that the unlawful act would result in that type of loss or injury. And in that case, it was an undercover police informant had formed a sexual relationship with an activist, and the claimant was the resultant child from that relationship. And the father then later, he said, left the scene to avoid prosecution. The claimant alleged that they had suffered psychiatric injury as a result of finding out over 20 years later that her father was not a political activist, but actually an undercover police officer. And that the father was purporting to fill a parental role under a false identity, and also from the father abandoning his parental role using a false explanation. So she said all of these things that caused her psychiatric harm. And in that case, the judge held that for the claimant to successfully make out the tort of misfeasance, they had to establish some degree of awareness on the part of the father of the consequences of the unlawful act, resulting in the loss or injury to the claimant. However, there was no requirement to establish that it was probable as opposed to likely consequence of that. So what's needed is an awareness that the unlawful act is going to cause that type of loss or injury, but it's not, as the court rejected, that it only needed to be probably, didn't need to prove that it was likely, that the defendant was aware that that kind of harm was likely. As we've already touched on, the relation to the type of harm, so some injury, some type of injury or harm being foreseeable is insufficient. The defendant must have had knowledge of the type of losses claimed. So in Eurasian Natural Resources Corp and Descartes LLP, that was a case where a claim in misfeasance was brought against serious fraud office, because officers had induced a breach of contract. However, they had not known the loss that the company would sustain as a result. Knowledge of the type of loss of harm would not be satisfied by an awareness of some unspecified loss. So it needs to be an actual knowledge of the type of loss that would be suffered. A general awareness that there might be some kind of harm is not enough. And quickly on causation, but for causation must be satisfied, but it's not sufficient in and of itself. As we've already said, it must be the type of harm foreseen. So, for example, if we went back to the police informant case, if he'd murdered somebody, that's exactly the type of harm that was foreseen. However, if he'd accidentally hit somebody with a car, that's not, even though but for causation would be made out. It's not actionable per se, so actual harm and damage is required. And if it's a claim for psychiatric injuries, it does need to be a recognisable psychiatric injury. There needs to be a diagnosis, so distress or injury to feelings is not enough to bring a claim in misfeasance. There are a few distinctions from negligence, so there's no requirement to establish a duty of care. There's no requirement to establish a proximity to the victim, and exemplary damages may be claimed. In relation to limitation, so it's generally 6 years under Section 2 of the Limitation Act. However, where it's a claim for personal injury, limitation is governed by the personal injury limitation and not by misfeasance limitation. And similarly, if it's misfeasance has caused death, limitation is covered by Section 12 and not Section 2. Moving on to malicious prosecution. Those are the 4 ingredients that are required to make out a claim in malicious prosecution. So it needs to be, the claimant needs to have been prosecuted by D. The proceedings have to have been determined in the claimant's favour. The defendant has to have acted without reasonable or probable cause, and they have to have been malicious. So prosecution, they're very old-fashioned definitions set out there, but they are still the ones that are relied upon. So prosecution in this context is to set the law in motion. And that happens through an appeal to someone clothed with judicial authority in regard to the matter in question. So the claimant must demonstrate that the defendant has acted in a manner so as to be responsible for the initiation of proceedings. And that ties in with the definition of prosecutor. So because initiating criminal proceedings in this instance, more than one party will be involved. What the claimant will have to show, and it's going to be very fact sensitive, is that it is the defendant's act that is responsible for doing so. So it's case law has indicated that it might be possible. So in relation to the initiation of proceedings, there have been obiter comments indicating that it might be possible that if the police have deliberately suppressed information which would reveal to the CPS that the prosecution have become baseless, that might be sufficient for the police to be treated as a prosecutor for the purpose of malicious prosecution. But that hasn't actually been tested in a case yet, but it's something that there have been indications obiter might be sufficient, so we need to keep an awareness of that. So I said this is very fact sensitive, and it's going to turn whether or not on the facts of the case, the conduct of the police in terms of what they have done or omitted to do in relation to the independent prosecutor satisfies the components of the tort. And there are two cases there. So in Reason, the Commissioner for the Metropolis, the officer's conduct had been such that the CPS were deprived of their ability to exercise truly independent judgment. But in the Scottish case of Greer and the Chief Constable of the Police Service of Scotland, the police were not the prosecutor because in those circumstances, the Crown hadn't been deprived of their ability to exercise independent judgment. So it's going to be very, very fact sensitive as to whether or not the actions of the police in circumstances have deprived the CPS of their ability to exercise independent judgment. Resolved in the claimant's favour, this is probably the easiest conceptually to get your head around. So obviously acquittal is the resolving of criminal proceedings in the claimant's favour, similarly offering no evidence. What is key is that the proceedings are brought to an end. And so if they're still ongoing, there can be no cause of action in malicious prosecution. And as I said there, it doesn't need to be conclusive, so that can be satisfied if the proceedings are abandoned. What needs to happen is that they've been legally concluded. So moving on to reasonable and probable cause, and there's a quote there from Herniman and Smith, but the test requires essentially two branches: a finding as to the subjective state of mind of the police officer so that they have no honest belief, and also an objective consideration of the adequacy of the evidence, so the circumstances are such that they would lead an ordinary and prudent man to believe in the charge. When looking at whether or not there is reasonable or probable cause, the fact that evidence contains inconsistencies does not necessarily signify an absence of reasonable probable cause where the officers had an honest belief in the truth and the evidence taken as a whole, so standing back and looking at everything, give reasonable grounds for belief. However, in contrast, there's case laws held that where a police officer who arrested and prosecuted a claimant for willful obstruction of a constable in the execution of his duties and was found to have initiated the prosecution without even having considered for and the circumstances of the claimant's allegedly obstructive conduct did not have reasonable probable cause because he's clearly not turned his mind to it at all. Evidence showing a prima facie case may be sufficient, and it will be if the police officer proceeds on such information as a prudent and cautious person may reasonably accept in the ordinary affairs of life. So it's somewhat of a common sense approach, and mere suspicion, however, will not be enough. Malice, so improper motive, lies at the heart of malicious prosecution, perhaps unsurprisingly. While this requirement is an independent requirement from a lack of probable cause, it can be inferred from it. So the absence of probable cause with the absence of a proper motive can be, depending on the case, enough to satisfy the evidential burden of malice. So in Rees and the Commissioner for the Police of the Metropolis, it was concluded that the honest belief in the guilt of the claimant did not negate the existence of malice. So the judge ruled that the senior investigating officer's preparation of the prosecution was tainted by illegality of a serious kind, and that was the intention to pervert the course of justice. and this finding was sufficient to render him malicious. He knowingly put before the decision maker a case which he knew was significantly tainted by his own wrongdoing, which he knew could not properly be presented in that form to a court. And to find that there was no malice in such a case would be a negation of the rule of law. So even if they have an honest belief in the claimant's guilt, if they go about getting it in illegal ways, as set out here, that doesn't cure the problem, that doesn't get them out of malicious prosecution. I should have said, and I think I've accidentally deleted a slide, it's also not actionable per se. You do have to prove damage in malicious prosecution as well. So that's my own tech failure, but that's an additional requirement. So I think there's one question in the Q&A. So I think that's for me. So how would you advise demonstrating that police did not deprive the CPS of their ability? It's a difficult one, Bradley. It's all quite fact sensitive. But it will depend on whether or not what they have presented to the CPS is sufficient for the CPS, I would say, to have a good view on the evidence of the case. So it's going to be fact sensitive, but if the CPS are able to make an adequately independent judgment, I think that's the test that the court will be applying. There's a question there about the range of compensation for false imprisonment per hour. I don't know if that, Ella, potentially falls within your ambit or not at all. I think that's slightly outside the scope.
I think it is a little bit outside the scope of this talk, and it's not necessarily a question that permits of an easy answer. You need to look at the cases in respect to false imprisonment.
I think that's it, and I don't think there are any accidentally lurking in the chat either.
No, not that I've seen.
Okay.
No, I think that is all of them.
That's fab.
Well, thank you very much. If anybody does have any burning questions they've missed, our email address is there. Please do feel free to email us and we will answer them if we can. Thank you guys very much.
Thanks very much. Thank you. Bye.